My name is Corey Giordano, lawyer at Supreme Advocacy, LLP. This video is to help you prepare and familiarize yourself with the appeals process at the Supreme Court of Canada. Number 1. Notice and constitutional question. Notice of appeal. Congratulations, leave to appeal has been granted. Your client now possesses a significant opportunity, the right to appeal at the Supreme Court of Canada. A kind of special permission to appeal has been granted by the court. But in reality, the door has merely been opened. It is still for you and your client to walk through. Alternatively, your client has an appeal as of right. In either scenario, an appeal is perfected by filing a notice of appeal in Form 33A. There is no specific requirement to set out the grounds in the notice of appeal. However, if your client wishes to limit the grounds pursuant to Section 57 of the Supreme Court Act, they must express that wish in the notice of appeal. In the case of an appeal as of right, both the appellant and the respondent must file a certificate in Form 23A, and if applicable, in Form 23B. The form indicates whether there exists a publication ban, a sealing order, or confidential information in the file. If applicable, Form 23C states that an SCC judge's prior involvement or connection to a case makes it inappropriate for that judge to adjudicate. Notwithstanding Section 63 of the Supreme Court Act, the registry no longer requires that the appellant request the Court of Appeal transmit the case to the Supreme Court. Instead, the court will rely upon the appellant's record and any respondent's record as the source for evidentiary materials. Constitutional questions. Where a case raises constitutional issues, a notice of constitutional question in Form 33B must also be filed as a schedule to the notice of appeal. On the same day the notice of constitutional question is filed, a copy must be served on all other parties to the appeal and all attorneys general, together with hyperlinks to the judgment granting leave and reasons from the Court of Appeal, the legislative provisions at issue, and, if applicable, the relevant charter provisions. For respondents, a notice of constitutional question must be filed if an issue has been raised by the respondent within 30 days after leave to appeal has been granted or after the filing of the notice of appeal where leave is not required. Number 2. Deadlines in the various procedural steps in an appeal before the Supreme Court of Canada. Deadlines at the Supreme Court of Canada are determined by the filing date of the notice of appeal and by the rules of the Supreme Court of Canada. You can think of your notice of appeal as starting to stopwatch on the appeal. All future procedural deadlines, unless ordered otherwise, are oriented in relation to the notice. The rules provide for extensions of time. That's Rule 6. However, we caution that Rule 71.3 states respondents and interveners will not be allowed to present oral argument at the hearing if their factum has not been served and filed as required. Failure by the appellants to file either the notice of appeal or their factum materials on time can result in the dismissal of the appeal pursuant to Rule 65. So any motion to extend time must be carefully considered. With that word of caution, let's examine some of the specific materials to be filed and their associated deadlines. Appellant's materials. Rule 35.1 of the Supreme Court Rules provides that an appellant's factum must be served and filed within 8 weeks of the filing date of the notice of appeal. As noted, Rule 65.2 adds that if the appellant does not serve and file the appellant's factum as set out in Rule 35, the respondent may apply to a judge for dismissal of the appeal, or the registrar may send a notice of intention to dismiss in Form 65. Where applicable, Part 6 of the factum must provide submissions on the impact that any sealing or confidentiality order, publication ban, classification of information in the file as confidential, or restriction on public access to information in the file could have on the court's reasons on appeal. Respondent's material. Rule 36.2 provides that the respondents must serve and file their factum, book of authorities, and record within 8 weeks from the date of service of the appellant's documents. Appellant's reply. The rules do not provide an appellant with a right to a reply factum. If for whatever reason an appellant believes it's necessary or desirable to file reply submissions, a motion must be brought. This means there are no hard and fast deadlines. Instead, the registrar typically makes a decision. Where an appeal includes interveners, an appellant will typically wait until after the intervener's facta are filed before determining whether there is a need to make reply submissions. As interveners must come before the court with a different perspective and provide submissions that are both useful and different from those of other parties, interveners often raise issues that an appellant feels compelled to address. A word on intervention. Intervening in an appeal is made pursuant to Rule 56. A motion for intervention must be filed within 4 weeks from the date of the filing of the appellant's factum. Rule 37 provides that an intervener must serve and file its factum within 6 weeks of the order granting leave to appeal. The rules provide for special time limits in the case of attorneys general or automatic interveners. Number 3. Important considerations. Posting of factums and leave applications on the SCC website. Both you as counsel and your client should be aware that factums and memorandum of argument filed in cases in which leave to appeal has been granted may be posted on the Supreme Court of Canada website. Therefore, it's important for you and your client to have a conversation about this in advance. Parties are required to confirm which documents are suitable for posting. If you and your client determine a document is not suitable for posting, a redacted electronic copy must be filed. The following information should be omitted. Information subject to a sealing order or ban, personal date identifiers such as date of birth, identifying numbers such as telephone numbers, social insurance numbers, or bank account numbers, addresses, and biometrical information such as fingerprints. Personal information does not include an individual's name, if he or she is a party to the proceedings, or the name and business address of a lawyer who is acting as counsel or agent for any party to the proceeding. Number 4. Preliminary information about the hearing itself. Approximately 2 weeks before the hearing itself, our practice at Supreme Advocacy LLP is to provide a detailed summary with specific information on the appeal hearing. That's right down to what time to get there, what entrance to use, where the barrister's changing rooms are, and where the washrooms are too. The following is some preliminary information for your consideration in the meantime. Appeal hearing date. The court may write to you advising of an approximate date for the hearing. Remember, this date is entirely tentative. The date could easily change. It may be moved to an earlier session or back to a later session. Time for argument. 1 hour each side. The appellant has 5 minutes reply. If there's more than one appellant or more than one respondent, each side still only has 1 hour and therefore must work out the time allocation themselves. How many can argue? The Supreme Court of Canada prefers 1 counsel per side, though 2 are permitted. Please note that for interveners, only 1 counsel is permitted. Additional time. A party may bring a motion for additional time beyond the 1 hour, but we would expect such a motion to be granted on strong exceptional grounds only. Similarly, one could bring a motion for additional pages beyond the 40-page factum maximum, but again on strong exceptional grounds only. Even if your appeal is scheduled to be heard in the afternoon, you are required to be gowned and present during the morning appeal. If it ends early, you're on immediately. Non-counsel at counsel table. If you wish for a staff person or articling student to sit beside you, you must request permission from the presiding justice at the start of the appeal. Translation. Simultaneous translation is always available. TV and webcast. CPAC, the cable public affairs channel, will record the appeal for later broadcast, but only if both sides agree. The court will send you a consent form in advance or ask you to sign one the morning of the appeal. If you have any concerns, please call us at Supreme Advocacy LLP. After the appeal, we can arrange to get you a copy for the home video collection. Unless it is a closed hearing or subject to a ban, the hearing will be broadcast live on the SCC website. The court also prepares transcripts of the appeal hearing which can be obtained for a fee. Again, please let us know. We're happy to arrange to get you a copy. We end with this note. As your Supreme Court of Canada agent or as co-counsel with you, we are here to help you win, but we're also here to help you with any assistance you may wish on any matter, and that includes speaking or meeting with you as to questions certain judges may ask you from the bench based on our past and continued experience at the Supreme Court.